This program is made possible by listeners who choose to support Frontlines and Backrooms. You can join our community of supporters through the link in the episode description. Thank you.
From Lisbon, Frontlines and Backrooms podcast. Your host, Vladimir Bobatic.
My guest today is Oona Hathaway, a professor at Yale Law School and one of the leading experts of international law and the use of force. She previously served at the Pentagon, advising on international legal frameworks during times of conflict. At the moment when the foundations of the international system are being openly challenged, we speak about whether the rules are simply being broken or whether they are being rewritten in real time. We discuss the role of the United States in this shift, the growing silence of the international community, and what happens when the most powerful states in the world begin to act outside the system they once helped build. Professor Hathaway, thank you so much for your time and welcome to Frontlines and Backrooms.
Thank you for having me.
You recently noted that the world is waking up to a reality where the United States can no longer be relied upon to play the parental role in the international legal system. In the context of the current April 6 ultimatum, is the United States merely violating the rules, or is it successfully rewriting the baseline norm from one law to one of might makes right?
Well, I think we're still early to say with some certainty about whether the rules are radically changing or whether we're just witnessing a law breaking. And your listeners probably know this, but just as a bit of background, the United Nations Charter, which the United States, of course, not only signed and ratified, but championed at the end of World War II, prohibits states from unilaterally resorting to force. The only lawful basis for states to resort to force is if it's authorized by the UN Security Council or if a state is acting in self-defense against an armed attack. Neither of those is true here. There hasn't been any claim about an imminent threat. All of the talk about the kinds of threats that Iran posed were general, broad claims about, general concerns about long-term threats that Iran might pose. No sense that there was some kind of immediate threat that necessitated unilateral military action, as opposed to going to the United Nations Security Council, making the case that there was a necessity for military action and then getting international approval for acting. So this is clearly in violation of UN Charter. I think pretty much every international lawyer that I've heard speak about it has come to this same conclusion. So then the question is, are we witnessing just an act of outrageous and clear violation of the Charter, or are we witnessing some kind of a radical reorientation of the international legal order? And on this question, I think we can't just be looking at what's happening in Iran. It takes a longer view to get a sense of what we're seeing. Of course, this latest intervention in Iran is in violation of the Charter, but it's not happening in isolation. There's, of course, actions by the United States under the Trump administration, the Venezuela operation, also a violation of the UN Charter, the strikes on nuclear facilities in Iran during the summer, also a violation of the UN Charter. But then, of course, you have to look back a little bit further, not that much further, to see Russia's invasion of Ukraine, also clearly a violation of the Charter regime. And then another of the P5 members, permanent 5 members of the Security Council, China, less noted, but still has been building its military installations on contested rocks, islands, and reefs in the South China Sea, and that seizing of territory that's contested is also its own kind of violation. So we're seeing a whole host of these violations, and it's that that begins to add up to something that looks more epic changing, more fundamental as a challenge to the UN Charter regime. And just last thing on this, it's not just the fact that there have been these violations, but it's also the way in which states have reacted, or in the case of the US's intervention in Iran, failed to react. So when Russia invaded Ukraine, it was a clear violation of the United Nations Charter, but there was this massive response. There were a series of General Assembly resolutions, vast majority of states voting to declare it illegal, a huge sanctions regime put in place, lots of states coming to Ukraine's defense by providing support, US really leading the charge and all of that. And that response, in a way, was an answer to the violation. It was a way of sort of building up the international order in response to the assault by the Russians. But what we're seeing in Iran is an extremely tepid response from other states. States are, I think, scared, frankly, to call out President Trump. They're afraid about the consequences that they might face if they go up against Trump. And so you're hearing a very, very little out of the international community in defense of the international order. And in a way, it's that silence that, to me, is the most foreboding for the international system.
Professor, are they afraid just of President Trump, or is it also because Israel is involved in this war? We know from the example of Gaza that the other countries were reluctant to react fully, as in other cases, because it was Israel in question.
Yeah, I mean, I think that may be playing a role here. I mean, particularly for Germany, which I think has this sense of historic responsibility and therefore, generally speaking, is reluctant to call out actions by Israel, particularly when Israel feels itself to be acting in its own self-defense. And that may be part of the story here, but I don't think it's the entirety of it. And I think also part of the story here might be that there's not a whole lot of sympathy for Iran, which has been a pretty negative actor around the region and indeed around the world. It's supported Hezbollah, the Houthis, a number of malign actors in the region. It's provided drones and other kinds of weaponry to the Russians to assist them in their unlawful war against Ukraine. And so it's a little rich for them to turn around and say, hey, wait a minute, this international legal order means you can't do this. And there's a lot of states that are not so sympathetic to that. And I understand that reaction. I think that is understandable. But I think a bigger piece of the story here is that states are nervous, frankly, about calling out President Trump, who really is the one fundamentally responsible for this war, because you never know what he's going to do. You never know when he's going to slap a tariff on you, or he's going to say, pull out of NATO, or withdraw all intelligence support for Ukraine, or otherwise undermine significant national security interests that states have. And so they're kind of tiptoeing around him right now, and I think afraid to call him out. And there's a bit of a collective action problem here, because I think no state kind of wants to stick their head up and be the one to criticize Trump. But then what you have is a collective silence that really resonates. And there have been a few states, I will say, that have stepped up. Spain is one of them that got kind of slapped. But for the most part, states have been pretty quiet, and that's for me in many ways the more worrisome sign for the international order. When there's a clear violation of international law and nobody reacts to it, that's a sign that something is pretty broken.
You rightfully mentioned Russia because of the invasion of Ukraine. So this is not only about the United States. If we have the most powerful countries in the world breaking the rules of the system, does that simply awaken the system, or does it permit others to do the same?
Well, I mean, that's certainly the worry, right? That states are going to see this as effectively green lighting violations of the United Nations Charter, is sort of saying, hey, these rules don't really apply after all, and states can use military force for reasons that of their choosing. And here it's important to remember that the international system that we've had since World War II is really of recent vintage. um, Before 1928, states were lawfully entitled to use force for any purpose whatsoever. And they were lawfully entitled to use military force to enforce treaty obligations. They could use military force to collect debts. They could use military force to defend trade routes. They could use military force to respond to violations of customary international law. They could use force for a whole host of reasons. It was really up to them. They had to have a legal claim, but the legal claims were pretty endless. In 1928, states agreed to outlaw war in the much maligned, what's known in the United States as Kelly-Brand Pact, but also sometimes called the Paris Peace Pact. Um, and that idea of outlawing war was reinforced in the UN Charter. That's really what becomes the core of Article 2.4 of the UN Charter, is this idea that states can't unilaterally resort to force. But that's pretty new. It's less than 100 years old. And the UN Charter rule only dates to 1945. And so, it has been true in the past that states have used force when they wished. And that was a much more violent world, but it was also a world in which armaments were much less powerful than they are today. And so we could very well see ourselves moving back to a world in which states consider the use of force up to them, and that they get to decide for themselves when they're going to use military force, and they don't have to go to the Security Council, and they don't have to show that they have a self-defense justification. But they're going to be doing so in a world in which they have a lot more firepower, and including nuclear weapons, which didn't, of course, exist until till towards the end of World War II. And so that's a lot more dangerous. And I really fear for what that system could become.
The UN Charter was adopted in 1945. The organization is just 8 years old or young, but it helped keep the world out of a major global conflict. On the other side, if that system, if international law only works when powerful states, the United States, Russia, and China, choose to follow it, is it still a law or just the language we use to justify power?
Well, law and power have a complicated relationship. Sometimes when there's a kind of sense of putting them in opposition with one another, that if power matters, then law doesn't matter, and if law matters, then power doesn't matter. But the truth is quite a bit more complicated than that. Why did we create this prohibition on use of military force? It was because a powerful state supported it. They're the ones who wrote the United Nations Charter at the end of World War II. And they wrote into the rules this idea that there would be a prohibition on use of force. Why did they do that? They did that because they had just fought 2 world wars. They knew the costs of global conflict. They believed that the only way to prevent that was to prevent states from making unilateral decisions about using military force. And they used their power to create these rules, which were, by the way, in the interest of everybody else. And other states also signed on to that because they believed that those rules were in their own best interest. We have 193 states that have chosen to ratify the United Nations Charter, that joined this legal regime and agreed to renounce the right to use military force, and to join this collective agreement that provides for keeping the peace. So powerful states helped create that. They supported it, and then they have, over the years, helped enforce it. So when Iraq invaded Kuwait, the U.S. helped lead the charge in a Security Council authorized response to force Iraq out of Kuwait. And so, power helped maintain the system, but it was used to enforce these legal rules. But law isn't just power. It isn't just reducible to what the powerful want, because once the laws are in place, the law takes on an authority and a power that is um, beyond the power of just the powerful states, because it takes on the authority of legitimacy, and all states begin to expect that everyone else is going to abide by these rules. And if they don't, then there's going to be consequences. So Russia is quite a powerful state. It's a nuclear power state. When it violated the UN Charter by invading Ukraine, there were a lot of consequences that followed. Massive sanctions, lots of support for Ukraine, intelligence support for Ukraine, economic support, military support, and repeated condemnation of its violations. And it's paid a pretty substantial price. It's lost a lot of soldiers in the course of the war. Now, has that been enough to stop it? No. But has it paid a major price for its decision to violate the law? Absolutely. And so I think we can't see these as sort of polar opposites. They're operating in tandem with one another and in conjunction with one another. And law is not reducible to power, but power is also, if law has zero power, if there's no powers who are willing to support it, and that could be collective power, then it also loses its authority and legitimacy and its ability to shape what states do. So it's a much more complicated relationship than I think is sometimes appreciated.
We are seeing at the moment 10 days extension of President Trump's ultimatum, and many view that as a logistic window for a rear armament rather than a diplomatic one. So, from a legal standpoint, when a pause in hostilities is used to prepare for a later strike, does that run a necessary and proportionate self-defense into a legal function?
Yeah, I mean, I don't think there's any, like, from the US perspective, I don't think the US is engaging in a lawful use of self defense, force as a matter of self defense under Article 51. I think this is not a lawful war. And I think that the threats that President Trump has issued to attack energy infrastructure and water desalination plants in the region, excuse me, are threats to engage in war crimes. And he may be doing this just as a matter of leverage to try and get some bargaining authority, but it's extremely damaging to have the president of the United States threatening to attack civilian objects, and um, you know, to destroy water facilities that millions of people depend on. So I don't think there's any way of justifying that under any form of international law. And I would hope that the president would retract that threat, although I don't. I don't expect that he will.
Many were seeing the United States as a shining beacon on the hill, and now we have a State Secretary of Defense, Mr. Pete Hegseth, who said no rules of engagement, no stupid international law, and no mercy to captured enemy soldiers. So, what does this tell us about the current situation in the United States and on the battlefield today? Do soldiers and commanders still think in legal terms, or have the law become something that exists only on paper?
It's not just that the law exists only on paper. I think that would be an extreme statement. I do think that the Secretary of Defense is deeply misguided and has made a number of statements that themselves could even constitute war crimes. The threat to give no quarter, for instance, if that is interpreted as an order, would be a war crime in and of itself. Um, it's clear he doesn't care about the law, but that doesn't mean that members of the military who are actually carrying out these military operations don't care about the law. And in fact, it is a deeply ingrained part of the U.S. military culture, um, such that it would take a lot to overcome that commitment within the U.S. military. Um, Now, the way that the U.S. military has been trained for years is, deeply ingraining these rules within the military culture. it is part of how the U.S. military operates. It's not to say that it is perfect by any means, and I've written lots and lots of articles criticizing the way in which this has been operationalized. But I will say that I also do believe and appreciate that it has been an important part of the culture of the department, and I believe it remains so. But a culture could be destroyed, and if you have firing of lawyers, if you have firing of JAGs, the judge advocates generals who are important for ensuring that law is followed, if you have a gutting of the Office of General Counsel, if you have the people whose job it is to oversee those rules and to review the rules of engagement to ensure that they're consistent with international humanitarian law, if you have adoption of AI technology that is not sufficiently attentive to the needs to protect civilians, if you're using outdated information in your targeting decisions, then that is an assault on the international legal order. It's an assault on the traditional culture of the Department of Defense. And it could result in war crimes. And we may very well be seeing some of those happen. And we've just seen strikes on now 2 schools have been documented by the U.S. The girls' school that was reported some time ago. And then there's recent reporting now about in the opening days, there was a strike on another school and a sports facility that killed upwards of 21 civilians, according to reporting, and injured over 100 civilians. And it seems that there was widely available information to suggest that those were, in fact, civilian entities, that they were schools, that while they were close to military facilities, that these structures were well known to be, and widely disseminated information suggests that they were civilian, and not just civilian, but schools with children in them. If the targeting decisions were not taking into account widely available information that has been available for over a decade as a part of the targeting information that's being fed into these systems, with a knowledge that that failure was inevitably going to lead to the deaths of civilians, that could constitute a war crime, because recklessness is sufficient to establish willfulness. And so I hope that that's not the case. And I know that there are many people in the Defense Department, many lawyers, many members of the military who deeply believe in international humanitarian law and are as appalled as any of us by what's been happening. But I also think there's a message from the top that we don't care about these things. And there's really a kind of culture war going on within the department, I expect. And, there's people who are holding on for now, but I worry about what's going to happen over the course of time, because those who believe in these rules, who are seeing these violations take place, are leaving and are giving up, and as that happens, that has consequences for what the future is going to look like.
When you are at war, no matter which army is in question, but the US Army in particular, because it is the most sophisticated in the world, targets are not chosen randomly. There is a very thoughtful process of choosing the targets, but mistakes can happen no matter how good you are at planning. Those mistakes have a term, collateral damage. How much collateral damage is in relation to international law, especially when we are talking about warfare? I'm asking you this because it looks like this administration doesn't want even to use that as an excuse.
Yeah, I mean, so there's 2 kinds of reasons that you might see civilians killed in targeting that, where they're not being intentionally targeted in the sense of, you're trying to indiscriminately target civilians. So one is known as collateral damage. And basically what that is when you're seeking to target a military objective, a lawful military objective, say a missile site, and it is, say, they say they're civilians who are working on that missile site, or say that it's next door to a apartment building, and in destroying the missile site, inevitably there's going to be some damage to the apartment building. And there's no way to minimize that. So generally speaking, the way that you try to deal with this is you choose armaments that are necessary. There's a minimum necessary to destroy the target that you're seeking to destroy in order to minimize collateral damage. But let's imagine for the moment that you can't do that, or that or another case that we often see in counterterrorism operations is there, say, a weapons depot that's located within a civilian residential area. And you try to blow that up, and inevitably there's going to be some civilians. You know that there's going to be some civilians that are going to be killed in the process. There, the principle of proportionality requires that you have to assess the expected harm to civilians and civilian objects, and that can't be excessive in relation to the concrete and direct military advantage anticipated, but it doesn't have to be zero. So that's collateral damage. There's another way in which civilians get killed, and this is, I think, what we're seeing with the school strikes, is that you think you're attacking a military objective, but it turns out you're wrong. And these are pretty common. Some of the biggest civilian casualty incidents are of this second kind, where your intelligence is wrong, or you have bad information, or you have outdated maps, or you're observing something from the air and you just didn't notice some important set of information. And then, generally when that happens, people say, oh, that was a mistake. That was, a terrible mistake, a tragic mistake. And I wrote this article called Mistakes in War with Azmat Khan, my co-author, who's a reporter at New York Times, where we argue that, and we show that merely calling something a mistake doesn't get you out of responsibility. That if you are making a mistake where you've been reckless, that you failed to take account of information that was reasonably available to you, that you should have known, you should have taken advantage of, that can be reckless, and that can still be a war crime. So there's kind of two different ways in which civilians might unintentionally be caught up in conflict. And collateral damage is lawful as long as it's not excessive in relation to the military advantage anticipated. Mistakes are lawful, but making the same mistake over and over and over again, and choosing to use information that is going to lead to mistakes, may not get you out of your legal obligations. That may be enough to constitute willfulness and therefore a war crime.
Professor, you've written extensively on the rise of dual-use objects. In a world where civilians with smartphones can track movements and share information, is the legal definition of a civilian becoming so narrow that it is losing practical meaning?
Well, that's the worry. And this is something I've written about both in the writing on dual use objects and in a piece that I did on what we call crowdsourced war, which is about the ways in which increasingly civilians are being drawn into conflict by use of decentralized technology, phones, and the like, that allow civilians to participate in supporting a war effort, and that might transform civilians into what are called civilians directly participating in hostilities. And if you are participating in hostilities, you lose your protection from being targeted, because you are no longer a civilian that's protected from conflict. You're actually picking up arms. If you're picking up arms, you now become a lawful target. And I've argued in my work that over the course of the counterterrorism campaigns, the U.S. has interpreted the targetable civilians in a way that is increasingly limiting protections for civilians over time, and that incidental involvement by civilians is increasingly putting them at risk of being targeted, and is really eliminating this set of protections that were really meant to protect civilians from being targeted in armed conflict. I don't know that that's what's happening in Iran at the moment, but it's certainly a part of a broader dynamic that we see, particularly in Gaza, during the conflict there, where it seemed that Israel was interpreting kind of everybody or many people as being participants in the conflict, even though they had very thin connections to the conflict, and probably because they're adopting this interpretation of civilians directly participating in hostilities. It's similar to the U.S. interpretation, which is extraordinarily broad, as well as they have a reading of the rules of proportionality that's at some odds with other states as well, that permits a much more uh, much less cautious approach to civilian casualties when seeking to target a military objective.
I want to stay a little bit more in the Middle East, in southern Lebanon, where the Israel army is conducting the ground operations. We see the destruction of infrastructure and homes alongside the border between Lebanon and Israel. Israeli Defense Minister Israel Katz said it is a policy of no return. At what point does targeting bridges and homes cross over to collective punishment or even a strategy of force displacement?
Yeah, I mean, I think this is one of the great challenges and tragedies of this conflict, and of the repeated fighting that's taken place in this part of the world over and over and over again. So the way in which law features here is that what are regarded as war-sustaining activities, so that could be just financial activities, are treated as targetable. And the U.S. has been doing this in targeting, it seems, some of the fuel um, uh, the fuel depots and other places where the oil is being collected to be sold. And you're seeing some of that happening as well from Israel, both in Iran and in other parts of the region. In Lebanon, I mean, look, uh, there's ongoing conflict in this part of Lebanon where Israel asserts that it's being used for targeting in northern Israel, and this is necessary for their own self-defense and defense of their population. And it is true that there are missiles being fired into Israel from southern Lebanon. So that and they have a right to defend themselves against those strikes. But whether they have the right to go in the way that they are and to assert that there's no right of return, that is not supported by international law. This is sovereign territory of another state. And while you're entitled to do what's necessary in order to prevent attacks on your population from the territory of another state, you're not entitled to essentially occupy that territory for the long term, or to insist that civilians not live in that territory going forward. So, to the extent that Israel is making those claims, that goes beyond what it's lawfully entitled to do.
One of the main issues with the United Nations at this point is the Security Council. Permanent members, but especially Russia and the United States, are abusing their veto power. They use the Security Council to protect allies. Can we prevent a full collapse of legal norms if the Security Council is going to stay blocked in situations when it matters the most?
Yeah, I mean, it's a perennial problem with the Security Council. So it's set up, and your listeners may or may not know this, but they're permanent five members: the U.S., Russia, China, the United Kingdom, and France. Those permanent five members each has a veto. And that means that even if the elected members, if the majority of the elected members and these permanent members vote in favor of an action, if a single one of those five states votes against, they have the right of the veto, and that prevents the Security Council from authorizing the action. Now, in a way, this was somewhat of a short-sighted design flaw that was built into the Security Council, although it was intentional. And the thought behind it was that we don't want to authorize wars where we would be putting these states on opposite sides of a hot war for one another. So it may be that there's a good argument that there should be an intervention, but if Russia and the U.S. are going to end up on opposite sides of a hot war, we shouldn't have it happen, no matter what, even if we have lots of good reasons for thinking it's a good idea. So, say, for example, Syria. There were lots of efforts to authorize a response to the civil war in Syria and to the horrific attacks on civilians that the Syrian government was engaged in during the civil war there. And Russia was vetoing it over and over again. And in many ways, that's a failure of the system. But in other ways, it's the way the system was designed to work. So it was designed so that the U.S. and Russia would not end up on opposite sides of a hot war. So if U.S. was to go into Syria and Russia was to come into the war on behalf of the Syrians, and Russians and Americans are fighting against each other in Syria, that's the kind of scenario that they were trying to prevent. So on the one hand, it's a design flaw, and on the other hand, it's working exactly as intended. So I think that's important to remember. Like, what was the purpose of this? The purpose was to prevent Armageddon. It was to prevent states who were the most powerful states in the world from fighting against each other and potentially, igniting another world war. But of course, it does mean paralysis for the Security Council in a lot of cases. So because Russia, China, and the U.S. so rarely agree, and one or the other of them is often ready to veto, and the U.S. and Russia are the main states that veto Security Council authorizations, it has meant that Security Council has not played as significant a role as one might hope in dealing with real terrible situations of international peace and security violations. So U.S. vetoed Security Council resolutions to deal with the situation in Gaza. Russia, of course, vetoed anything not only with Syria, but to deal with its invasion in Ukraine, predictably. So it's not going to be the solution to all problems. There has been an innovation at the UN, which is called the Veto Initiative, that was put in place in 2022. And basically, what it says is, if the permanent member of the Security Council vetoes a resolution, it automatically gets referred to the General Assembly. And I think that's important because it means that the General Assembly takes up the matter. And there is no veto in the General Assembly. Now, the General Assembly does not have, also all 193 states have a vote in the General Assembly. It doesn't have the authority to authorize military action, but it can pass resolutions that have real significance. So when Russia vetoed the various resolutions relating to Ukraine, that got referred to the General Assembly. And the General Assembly again and again passed a series of resolutions calling for Russia to withdraw, condemning the invasion as unlawful, kicking Russia out of the Human Rights Council, authorizing various kinds of sanctions. So there are a lot of ways in which it did have a real impact. But yes, the Security Council becomes kind of a non-entity, at least when it comes to authorizing military action in these cases. And of course, when it comes to Iran, since the U.S. is one of the significant actors, the chance the Security Council is going to be able to play a significant role without the U.S. being in support is zero. Because the United States would be able to veto any authorization. That's not to say the Security Council never acts. It did authorize intervention into Libya, though questions as to whether that turned out all that well. But and it has taken important steps, but it is limited by the veto, which again is depending on how you look at it, either a feature or a bug of the system.
You mentioned that it was designed with flaw. So if something is designed with flaw, is it repairable at all, or should we leave it as it is?
The UN Charter can only be amended with the consent of all of the permanent 5 members. And so it's exactly the same veto that prevents the Security Council from authorizing action in these contested cases that would prevent any significant change in the permanent members' control over the Security Council, and the chances that they would agree to water down that authority is zero. Could we see other kinds of changes? Sure. I mean, we could see an expansion of the elected members of the Security Council. That's happened once before. I could imagine that happening again, but that doesn't really solve this fundamental problem. So I've written this article called Non-Amendment Reform to the United Nations, and basically making the argument that the only kind of reform you're going to get at the UN is non-amendment reform. So no formal amendment, but through things like the veto initiative. So the veto initiative was a non-amendment reform. It's a practice that was put in place. It's a resolution that provides for automatic referral to the General Assembly. So those kinds of practices, I think, can emerge and have power. And can have an impact and can be a form of reform at the United Nations. But you're not going to overcome this fundamental fact of the P5 veto. That is, as long as the UN exists, that is, the P5 veto is going to exist as well.
So we are stuck. Now, when you said until the United Nations exists, I need to ask you about the Board of Peace. When you see the actions taken in Davos and in Washington meetings, it seems that President Trump is trying to make something that it is going to be a parallel institution to the United Nations, or its substitution. Look at the logo, paid permanent membership, peace troops, plus his unhappiness with the United Nations. What is he up to with the Board of Peace?
You know, I don't know exactly what he's up to be totally honest. The whole thing seems kind of absurd to me. And of course, when the Security Council authorized it, what they had in mind was something that was really going to be focused on Gaza, not the creation of an alternative to the UN and the UN Security Council. And part of the reason that many European states in particular have refused to participate is concerns that what Trump has in mind is the creation of a parallel scheme. Look, you can't create a parallel institution that has the authority to use military force without destroying the UN Charter, because the UN Charter gives the authority to make decisions about use of military force only to the UN Security Council. And so you can't create a parallel institution without undermining and essentially destroying the United Nations and the system that it's created. But here's what I would say about the Board of Peace. So I'm deeply skeptical about it, particularly, I mean, important to note that President Trump has designed it so that he personally gets to run it, even if he's not president anymore, which is total absurdity. But what I would say about it is, like, we've all been thinking kind of small. We've all been thinking within pretty narrow boxes. And if President Trump can dream up a Board of Peace, then maybe we have not been thinking, big enough. Maybe we haven't been thinking grand enough. Maybe we haven't been thinking about, what if you really tried to do some real institutional design? There are these fundamental flaws with the existing UN system that are insurmountable. And the UN Security Council, these permanent 5 members in the modern era doesn't really make any sense. And there's a number of things that we can see are huge limitations to the UN scheme. So I'm not suggesting we should throw it all together, but I do think that this encourages us to think big. And maybe to at least be a little bit creative, instead of just trying to sort of mess around on the margins or think that we're only limited to certain kinds of very small innovations. Maybe those of us who believe in global cooperation and international law should be thinking as big as President Trump is willing to think, and be trying to come up with big, creative, gutsy ideas that can compete. And so that's what I hope the inspiration is that we take from this idea.
Well, Professor, I hope that people are going to hear what you just said. But President Trump hinted that Cuba is next. So, given what we've seen in Venezuela, Are we moving from a reactive defense to proactive regime change as an accepted norm?
No, it's not accepted. I certainly hope not, and I don't think that it is. But I think that the international community has got to wake up to the fact that its failure to respond to each one of these actions that President Trump takes is enabling the next one. And the signaling around Cuba has been there for some time. It's something that Secretary of State Marco Rubio has been wanting to do for some time. And this devastating oil embargo that's been put in place has had extraordinary costs for the civilian population that are not getting well covered in the press because of everything else that's going on. But it's really stark, the impact that this is having on ordinary civilians in Cuba who are already facing real deprivation. And then he's talking about potentially going in and trying to change the regime. That is just such a complete affront to the international order that it's hard to even know how to think about it. But I think the fact that there was so little response to the removal of Maduro invites this kind of repeated action. And it should not be up to a single person to make these decisions. That's not how the international system is supposed to work. There are leaders in the world who are malign. There's no doubt about it. But solving that with unilateral military force by one state is not the solution. And I do worry that's the direction we're heading. And that's a recipe for extraordinary conflict. And unfortunately, ordinary people are going to be the ones who pay the price.
You've described our time as a really scary moment. Do you see a path back to the post 1945 legal order, or we are entering a fundamentally different era?
I've been writing for feels like the last 10 years about how important it is to maintain the international legal order and how we need to stand up for Article 2.4 and how we have to do what we can to maintain the international system. And things have just gotten worse, not better, over the course of that time. And the question is at what point do you say, okay, that is no longer a viable option and we've got to start thinking in a different direction? And we may be there. We may be at the point where those rules are no longer, that system is no longer viable. But the difficulty then is okay, then what's the alternative? What are we headed towards if not that? What is the system that would be put in place if it is not a system where essentially states are prohibited from unilaterally resorting to force, except if there's a collective agreement otherwise, whether it's Security Council or something similar? If it's up to individual states, what's to stop Russia from going into any state it wants to and decapitating it and putting in place the leaders that it wants? What's to stop China from doing the same? If the U.S. can do this, so can everybody else. And that seems not a viable long-term solution. If we head in that direction, it's going to be a moment of total chaos. And at some point, we're going to get to the point where we're going to realize, as we did at the end of World War II, that kind of unilateral resort to force is a recipe for disaster, and that we're going to need to limit the lawful resort to force. And we're going to go back to something that looks an awful lot like the UN Charter, I suspect. But I hope we don't have to deal with decades of conflict between here and there. And so, if that's the case, if in the end we're going to have to come back to a regime where essentially we agree that states don't unilaterally resort to force against one another, then maybe we can start thinking about how can we resuscitate that norm. And here, obviously there's lots to talk about middle powers and the role that middle powers can play. And I do think that is got to be part of the answer. There are a lot of states out there beyond the P5 states, and particularly the two states that really have done the most mischief in the international system, that have more power than they tend to use and tend to think. And they haven't really been using it. They haven't been pushing back effectively against Trump administration. And if they were to decide that they really stood behind the idea that states should not resort unilaterally to use of force, and they were willing to actually, put their money where the mouth is, and actually, stand up for the international system, maybe something could be saved of it. But, it gets harder and harder to have that belief the more we go down this road of unilateral use of military force. At the same time, there are 193 states in the world. So it's not just up to one or two states to decide what the international system is going to look like. But the other states, if they don't like the direction that the US and Russia are taking the world, really need to stand up for something else. And so far, they've been too silent. And they haven't done what's necessary to press back to maintain a more peaceful system.
At the end, we have 5 short questions for 5 short answers. First one, can a war be illegal if its political goal is unclear?
Can it be illegal if its goal is unclear? Yeah, sure, it can be.
Is deterrence today based more on law or on fear?
Both.
The legal limits actually restrain power or just described it after the fact?
I think legal limits constrain power, but less so now than I wish it were true.
Has the line between war and peace become meaningless?
No.
And the last one, is accountability in international law real or mostly symbolic?
I like to believe it's real. And I do what I can to make sure that it is. And I think we all should.
Professor Hathaway, thank you so much for your time.
Thank you very much for having me.
In the next episode, we speak with Dr. Roger Higginson about how Western policy perception and double standards shape today's conflicts, from Iran to Ukraine, a conversation about power, credibility, and what happens when the rules no longer apply equally. If you value long-form conversation that go beyond headlines and sound bites, consider to subscribe and support this project. It is because of the listeners like you that we are able to continue this backroom dialogue independent and in-depth. You can find the link to join in the show description. You've been listening to Frontlines and Backrooms, and until next episode, keep looking beyond the noise.